Press Club. Sitting here in front of you is Mr. Naga, Vice President Protocol, Arunachal Law Students Union, come Vice Chairman of this particular issue, and with my colleagues, Mr. Gyamar Maya, Chairman of this particular issue, and another Mr. Nagutara, AGS Admin, and Member Secretary of this particular issue. Yesterday, we submitted our representation to Honorable Chief Minister for repeal of Arunachal Pradesh Unlawful Activity Prevention Act 2014. And we, the team Arunachal Law Student Union, had already conveyed a meeting regarding this issue. और जहाँ में जितना भी जो भी लिखना है, जो लॉ को रिसेंटली क्या हुआ क्या नहीं हुआ, किस टाइप से उसको एक्ट को इस्तेमाल किया है डिस्ट्रिक्ट एडमिनिस्ट्रेटिव, तो बाकी जितना भी जो है फैक्ट एंड फाइंडिंग जो भी चीज़ है मेरा चेयरमैन जो ब्रीफ करेगा.
Thank you, media patronities. Today, we, the Arunachal Law Students Union, is here to brief about the Arunachal Pradesh Prevention of Unlawful Activities Act. This Unlawful Activities Prevention Act 2014. So, as my Vice President has already briefed that yesterday we have submitted a representation for repealing of this particular act. Here we came here to first thing we came here to brief about this potential of this act being misused in the hands of state authority. मेन चीज़ यहाँ पे हम लोग आज आया है. फर्स्ट मैसेज वी वांट टू कैरी दैट कि वी आर ट्राइंग टू एजुकेट द पीपल वे आउट टू फाइट द सिस्टम, वे आउट टू फाइट द सिस्टम इंटेलेक्चुअली एंड डेमोक्रेटिकली. अनदर थिंग वी वांट टू इनलाइटन, we are trying to enlighten the citizens of the state that about the potential of this act being misused in the hands of state authority in long run. So basically we have point out the lacunas of this Arunachal Pradesh Unlawful Activities Prevention Act 2014. So in this regard, in support of our representation, we are launching a moment called a citizen's call, a moment for right to freedom of speech, extra, and the right to life and liberty. Here our slogan is wake up Arunachal, speak up Arunachal. Our target is to ignite the mind of the people. Here you have seen lot of people are discussing about the misuse of this act. Misuse of this act to silence the voice of the people. But our people are not aware of the things, how we can fight against this law. We are not against any individual, we are not against any particular leaders, we are against this particular law. That has the potential to silence the popular voice of the people. So, first thing, our campaign is to enlighten the people about the draconian and unfair nature of this law. This law has a potential of being misused in very high extent. We cannot imagine how far this can be misused. So, first thing we are trying to highlight the very brief about this act. This act is a definition of unlawful activities under this act is very exhaustive one. That has the potential to bring any democratic movement within the ambit of unlawful activities. If you go through this act and the definition of unlawful activities, you will find that this unlawful activities, definition of unlawful activities has been defined so exhaustively that it can be interpreted in any manner for the convenience of the authority to silence the voice of the people. So we are against this law. This, in simple word, definition of unlawful activity provided under this act is broadened enough to bring any democratic movement under the ambit of unlawful activities. anything, any voice of the people can be bring under this law. You just read the definition of this unlawful activities under this act. Means such a unlawful activity means acting in such a manner so as to cause or likely to cause directly or indirectly any feeling of insecurity, danger or fear among the general public, any section thereof, or any danger to the safety of the individuals, safety of the public health, or the ecological system. See, the ecological system, the term ecological system is very wide. You cannot define in very, you cannot define in very simple language. It has very wide term, and they are using such terms. Here you can also find that any loss or damage to public exchequer. If there is a apprehension that the activities of the people can cause damage or loss to the public exchequer, there can that activities can be brought under the definition of unlawful activities, and people can be detained under this act. Damage, see the examples. Loss and the damage to public exchequer. See, I am just giving the example. Say example, the media paternity or whosoever raise a voice on certain pathetic condition of say government transport facilities. Say these facilities is not good enough to be used. So this kind of message, this is just a example. This kind of opinions can be given in democratic country so that the government can take corrective measures. But if you say this service is not good for people, this another in other way it can also cause a loss to public exchequer. That there is chances that the people may not travel in the public transport because of such kind of message, such kind of news. So there may cause a apprehension of causing loss to public exchequers. That definition, if we go by this definition, such kind of comment also be brought under this act. So this vague and vague definition and exhaustive definition of the unlawful activities is very dangerous for us. So we have pointed out that this definition of this act, and we have also a law, central legislation, that Unlawful Activities Prevention Act 1967. There the definition of the unlawful activities is very clear, very limited. There is no potential of misusing that act, that definition. But this act has a potential, unimaginable potential of being misused. So again, you go through this act. If you see this act, you will find that this Arunachal Pradesh Unlawful Activities Prevention Act 2014 is just a ditto copy of National Security Act. National Security Act 1980, except the definition of unlawful activities. Rest are just ditto copy. You imagine the National Security Act is a very powerful legislation. Intent and object of that legislation was very different. But ditto copy of this act has been formulated, enforced here with a different intention. So that point of time when this APUAPA Act was passed way back in 2014, I don't know what compelled the government or of that day to pass this act, but this is a ditto copy of National Security Act, which is meant to be used against the people who is against the national interest or sovereignty or integrity of the nation. But this APUAPA Act has very different objective, and this definition has given a very exhaustive, and it technically we can say that it has a power to silence the people's popular voice. So here we have pointed out some of the very dangerous provisions of this act. The Section 8 of this act indirectly says that power to keep detention without disclosing the ground of detention. Law in a criminal law as well as under Constitution of India, there is a provision that whenever someone is detained, as soon as possible, it has to be communicated to a person arrested or detained within a 24 hours. If delay, within 24 hours. But this act says that indirectly it says that as soon as possible, but not later than 5 days. That means you can keep the detainee under detention without communicating the ground of his or her detention for 5 days. Again, in here, provision says that in special circumstances, special cases, it can keep 10 days. That is very draconian in nature. Once you are detained a person, it need to give a opportunity to defend himself. That is the what the fundamental right says. But fundamental right here, the prevention, we have a lot of preventive detention laws in India. Most of that has been repealed. Most of that act has been repealed. But this law is actually a very draconian on actually not necessary at all in the state of Arunachal Pradesh. Another provision that powers to keep detention in 3 weeks without producing the representation of affected person. If you read the section 10 of this APUAPA Act, it says that when someone is detained, their representation is submitted to government. So government may produce that representation to advisory board within 3 weeks. Within 3 weeks means you can keep their representation without producing before the advisory board for 3 weeks. But that can be misused. The authority can intentionally keep the representation for 3 weeks. That law has given them power. These things are very draconian in nature. So denial of right to represented by legal practitioner. Section 11 of this act, Section 11, subsection 4, it says, whenever someone is detained under this act, he have no right to be represented by legal practitioner, that is advocate. Legal practitioner cannot represent him in any form. That is the thing. Another, Section 13, it says that the person can be detained maximum up to 6 months. If authority target somebody, by hook and by crook, by any means, they can keep you for 6 months, keep on extending by whatever the reason. They can produce before this advisory board, but they will advisory board, but when the simple representation is produced before the advisory board, it will not work. It has to be represented by someone who can explain the things very clearly to that advisory body. Otherwise, it will be not possible to convince the advisory body. The here act itself says that you will not right to represent by anybody or legal practitioners. Again, one of the very dangerous provision is the Section 15. Section 15 is very draconian in nature. It says that the temporary release on bond conditions. Say example, if someone is detained and someone is detained and keep behind a bar, and authority will automatically bargain him. I will release you only on that condition, on temporary ground. This is a tactic to silence the activists. Technically, it will silence the people. Whoever detained under this act will be bargained in this bar, behind the bar. Government will offer them, I will release you on such and such condition, such and such condition, or you will be temporarily released on such and such condition. That condition may be condition may be very dangerous. So that technically what says that it empowers the authority to silence the activists or whatsoever people who are against the system, who are against the wrongdoings of the system. टेक्निकली आपको अंडर ले जाएगा, उसमें आप जेल बैठ के वो तकलीफ तो हर किसी को होगा अंडर में घुसाने के बाद। आपको उसमें बार्गेनिंग पॉइंट लाया जाएगा, आपको छोड़ देगा, आप कंडीशन देगा, आप निकल के ये इशू में मुद्दा में बात नहीं करेगा, आप निकल के ये इशू में बात नहीं करेगा, आप निकल के ये फलाना काम नहीं करेगा, आप निकल के ये फलाना, हर चीज तरह का आपको कंपेल किया जाएगा, कंडीशन दिया जाएगा। देन यू विल बी गेट रिलीज एंड यू विल बी साइलेंस फॉर एवर। हमेशा के लिए आप कि उस इशू पे बात करने नहीं सीखेगा। दैट इज द थिंग। ये जो है, ये लॉ जो है हमारा स्टेट में अभी जरूरी नहीं है। क्यों बोलने से, वी आर वेरी पीस लविंग स्टेट, वी डोंट हैव एनी टेररिस्ट ऑर्गेनाइजेशन और एनी आउटफिट ऑर्गेनाइजेशन। होम ग्राउंड से कोई ऐसा ऑर्गेनाइजेशन एक्टिव नहीं है यहाँ पे, और यहाँ पे कम्युनल हार्मोनी का कोई इश्यू नहीं है, डिसहार्मोनी का। पीपल आर पीस लविंग एंड छोटा छोटा चीज़ में जो हम लोग जो छोटा छोटा इश्यूज पे हम लोग स्टेट के खिलाफ में कुछ बोलता है, कुछ करता है, इट जस्ट इमोशनल आउटब्रस्ट होता है। इट्स नॉट एक ये प्री प्लान, एक ये कंस्पिरेसी करके कोई मूवमेंट यहाँ नहीं होता है स्टेट में। इट्स इमोशनल आउटब्रस्ट समटाइम, बट दिस एक्ट इज़ वेरी ड्रैकोनियन। ऐसे चीज छोटा छोटा चीज़ को टैकल करने के लिए वी हैव एनफ लॉ, एनफ लेजिस्लेशन इज दियर, CRPC is there, IPC is there, state has a lot of special law is there। अरुणाचल में बहुत सारा एक ऐसा स्पेशल लॉ है जो पब्लिक प्रॉपर्टी डैमेज को भी ये करने के लिए, कर्टल करने के लिए। रिसेंटली आपका 2020 में भी एक एक्ट लाया है गवर्नमेंट ऑफ अरुणाचल ने, अरुणाचल प्रदेश प्रॉपर्टी प्रिवेंशन ऑफ डैमेज एंड लॉस एक्ट 2020। यहाँ पे भी बोलता है कि इफ समबडी डैमेज द प्रॉपर्टी ऑफ गवर्नमेंट और समबडी डैमेज द प्रॉपर्टी ऑफ प्राइवेट पर्सन, देयर इज अ वे आउट। उससे रिकम्पेंसेट, उससे रिकवर किया जाएगा, उसको पेनल्टी दिया जाएगा। दैट लॉ इज एनफ। और प्रिवेंशन के लिए आपका CRPC इज दियर। इफ देयर इज एनी एप्रीहेंशन, आप कुछ करेगा लग रहा है तो CRPC इज एनफ। और वो करते आया है। कोई ये करता है, डेंजर हो सकता है बोलने से, गवर्नमेंट हमेशा, स्टेट हमेशा ये CRPC का प्रोविजंस को अप्लाई किया है। आदमी को डिटेन करके 24 आवर्स तक रख सकते हैं। दैट इज एनफ। ऑन दिस काइंड ऑफ सच काइंड ऑफ ड्रैकोनियन लॉ इज नॉट नेसेसरी एट ऑल। तो यहाँ पे आपको हमने हाईलाइट किया है। रिसेंट एपिसोड को आप देखिए, रिसेंट एपिसोड आई एम हाईलाइटिंग दिस एक्ट हैज बीन पास इन 2014। इट हैज बीन अप्लाई ऑन सो मेनी पीपल्स। पहले भी बहुत घटना हो चुका है जिसका ये एक्ट में एक डिटेंशन लाया गया है, और वो एक्टिविस्ट लोग आजकल परमानेंटली साइलेंस हो गया। दे आर नो लॉन्गर एक्टिविस्ट, दे आर नो लॉन्गर इन पोजीशन टू स्पीक अगेंस्ट द रॉन्ग डूइंग ऑफ द स्टेट। व्हाई? दे हैव बीन रिलीज ऑन द कंडीशन में उन लोग को रिलीज किया है। आप निकल के स्टेट में रॉन्ग डूइंग कुछ गड़बड़ होने से भी आप बात नहीं करेगा बोल के, that condition has been given। That is that is direct curtailment of freedom of speech and expression। That is direct curtailment of fundamental rights। In democracy, it is democratic dissent of the opinion is very important। Healthy discussion is very important। उसको अगर कर्टल करेगा तो कैसे डेमोक्रेसी चलेगा? ये वाला चीज़ है। We are trying to send a message to people about this technically this draconian nature of this law। Recent episode, you see the random detention of the poor activists। They have been detained only on the apprehension that they have announced a boycott। Okay, fine, you detain them, just you detain them, and under CRPC also there is provision you can detain them, and detain them once they are 24 आवर्स के बाद में या 48 आवर्स के बाद उसको छोड़ दीजिए ना। दे आर नॉट ए डेंजरस पर्सन, दे आर नॉट ए क्रिमिनल एक्टिविटीज़। ये जो है, ये एक्टिविस्ट के ऊपर में ये डिटेंशन जो है, स्टेट हैज विटनेस देयर इज ए पोटेंशियल ऑफ बीइंग मिसयूज दिस लॉ। देयर इज ए unimaginable potential. This law can be misused to unimaginable extent. At the same time, another point we have seen last episode is that even the minor person, juvenile has been detained. Juvenile has been detained under this act. This type of mistake can be go on in long run if this law exists. Innocent people, innocent juveniles can also be a victim of this law, this legislation. People of state has witnessed the potential of this act, how it can, there is a possibility of misuse. So we technically says this law is not required at all. There is enough legislation that can handle the situation in our state. And so we have an appeal to written a letter to this Honorable Chief Minister yesterday representation we have submitted for repeal of this act. So for this we launching a moment. We have announced we announced to launch a moment that in the name and the style of Citizens Call. Citizens Call, a moment for freedom of speech, extra and the right to life and liberty. Wake up, Arunachal, speak up, Arunachal. Here our first page of moment. First page of moment is in our first page of moment. We are going with the team, my representative, my savers. When we elect a leader, we endorse them to protect our interests. We endorse them to work for the welfare of us. That is the message. Here we want to say that this is the high time. High time we should be rescued by our representatives. So our call here is to my representative, my savers. So we are urging the people of state. We appeal the people of state across every section of the state, every individual of the state, every citizen of the state to write a letter to your own representatives, your local member of legislative assembly. You elect them, you send them to the legislature assembly for the endorsing him to work for your interests. So here is the time you write a letter to your concerned MLA. Request, try to convince them to repeal this act in next monsoon session of state assembly. That may be held in the usually monsoon session is summoned in the July to September, in the month of July to September. We are appealing the people of state to write your representatives. We are not asking you to write a letter to entire 60 MLA. We appeal the people of intellectuals of the society to write a letter to your representatives stating the draconian nature of this act and request, try to convince them to repeal this particular act. At the same time, we appeal the people of the state to write a letter to Honorable CM also for repeal of this act. This is why our moment, why we are taking the moment in the form of writing a letter to the representatives and the Honorable CM. So we are actually trying to educate the people. We are actually trying to educate the people intellectual and democratic way of putting the grievances to the government of the day. Through this letter, you put your grievances to your representatives. Through this letter, you put your grievances, your opinion on this law to your legislature. If you convince your legislature, if you convince your representatives, so we need not to go for such a ban call or something else. Definitely there will be a repeal of this act और repeal करने का simple सा तरीका है. We don't need the money. State exchequer का एक रुपया भी लॉस नहीं होगा. Assembly session तो होना ही है. उसमें टेबल करना है, just repeal करना है. That's the thing. Or people are saying कि it should be, people should go for a PIL against this act, something like that. PIL when we have a very democratic way of solving the issue, why we should resort to that PIL or something like that, costly affair? You know, the PIL, filing PIL is not easy thing at all. When you go to court, it's not easy thing. There is time taking, at the same time costly affairs also. We cannot challenge the state, we cannot dictate the state, but we can convince the people, our representatives. We are nobody to challenge the government, but we can put our grievances in very effective way, democratically or intellectually. This is the way we try to convince the people. So we are appealing the people of the state to write a letter to. After this moment, if uh, we people of the state and our publics or our intellectuals or our citizens, we fail to convince our representatives, and this act is not repealed in upcoming session, there next we will move another moment against the repeal, for the repeal of this very act uh, that will be the very different one. That will be exactly for supremacy of people in democratic republic. That will be the team supremacy of the people in democratic republic. That means people are the supreme, citizens are supreme in democratic republic. That moment will be the call for vote for fundamental rights, vote for freedom of speech and expression, vote for freedom of vote for right to life and liberty. That moment will be the next step. That will be our next step. And we handful of people, we are law students, and we representing a very intellectual platform. And we are only in handful of people. We cannot convince the government. We cannot convince every legislature. It is the duty of it is also the duty of the people, जो सिटीजन्स है, सबको आगे आना पड़ेगा. आपको अगर ये लॉ को आपको नहीं चाहिए, तो you have to come forward and express your opinion democratically and intellectually. This is the way, and we are showing you the ways and the means to achieve the thing. And if you are not participating in these ways, and this if you are not come up with these ways, if you are not go with this moment, we should not be blamed for the failure to repeal this act. That is our message. There any questions or queries?
आपको जो मूवमेंट बोल रहा हूँ, किस प्रकार का मूवमेंट हो? आपको जो मूवमेंट बोल रहे हैं ना, जैसे एक मूवमेंट जो मूवमेंट करने जा रहा है,
Yes.
तो किस प्रकार का मूवमेंट होगा?
Yes, this exactly. I have told you this. हमारा मूवमेंट का नाम तो सिटीजन्स कॉल मूवमेंट है. इसमें टेक्निकली फर्स्ट पेज में हमारा ये है कि we are urging the people of the state to write a letter to their respective representative at the same time to Honorable CM for repealing of this act. This is the first phase of campaign, and the modus operandi of this movement will be pamphlet distribution, talk show, and this letter writing only. That will be the letter can be passed through. You can write a letter. In today's nowadays, it is very easy to communicate your grievances. You write the letter, you put signatures, and you write your grievances, and put signatures, and WhatsApp your letter, email your letter, message your letter, or you can send hard copy through by post, or you can go to him and convince them and discuss about the draconian nature of this law. That will be the modus operandi. We are not resorting to any undemocratic means.
Being committed towards fighting against this draconian law until it is being repealed. So, if so, can you ensure the public that or you can promise the public in front of the camera that unless we will go to the last fight, we will not leave any stone unturned unless this particular law or act is repealed by the state government.
Yes. We are saying that we are launching a movement against this law, draconian law. We are campaigning against this law. We are appealing the people to write. We are appealing the people to come forward to fight against this law. But we cannot say that this we will be. We have made clear that we have already made clear that our fighting will be in two pages. First page is this one. Next page, if this monsoon season, if they don't able, we will again call another movement. And if that point also, if government authority not listen to us, we are hopeful कि government सुनेगा, authority सुनेगा. If people moves मास मूवमेंट में मास अगर अवेयर होकर बोलता है कि तो मानेगा होगा सोचता है, लेकिन नहीं होता है तो we cannot say that we will fight up to repeal of this act because we have limited powers. हमारा एक लिमिटेड वे ऑफ फाइटिंग है, वहाँ तक जाने का बाद वी आर बाउंड कि हमारा पास और कुछ नहीं होता है और वी डोंट वांट टू रिसोर्ट टू दैट वायलेंस.